Thank you for joining us on this video presentation, Best Legal Practices in Owning and Operating Rental Property. We're going to talk about leases and evictions. If you already haven't done so, please visit us online on our social media platforms, Facebook and Instagram, and like us and follow us for up-to-date video tips and interesting articles pertaining to landlord and tenancy matters. If you ever have any questions, we'd love to hear from you. You can visit us on our website at stonegate.legalservices.ca. All right, so let's get started. I'll start by telling you a little bit about myself. I come from a real estate background. I am a real estate broker, and from the past 15 years, our path from real estate has led us to manage small to medium-sized apartment buildings. And I used to manage them for my out-of-town and out-of-country landlords. And through that, we would go to the landlord and tenant board to pursue evictions. And often at the landlord and tenant board, I would represent the landlord client as a property manager or real estate broker. And more often than not, the matters would get dismissed because they would not allow me to represent them. And the reason for that is that only the landlord or their legal representative, being a paralegal or a lawyer, can represent the landlord at the board. So that's how Stonegate Legal Services was born, and here we are today. So just a little disclaimer, everything discussed throughout this presentation is for information only and should not be taken as or construed as legal advice. So we're just going to go through some preliminary slides just so you get used to the terms that I use throughout the presentation. We'll talk a little bit about the paralegals and a lawyer and what is the difference between them. So like realtors, paralegals and lawyers are licensed by a bigger governing body, which is the Law Society of Ontario. They are required to carry errors and omissions insurance and complete their continuing education credits throughout the year. Paralegals and lawyers, just like realtors, they also have to abide by rules of conduct. There's just a couple of differences. The first difference is the more obvious difference, being the fees. Paralegals charge lower fees and lawyers charge higher fees. And the reason for that is because lawyers can represent their clients in the higher courts, meaning family court, family law court, and higher criminal court, whereas paralegals usually represent the clients in the lower courts or tribunals, being the landlord and tenant the landlord and tenant board and the small claims court. Usually, lawyers do not have the knowledge or expertise to represent their clients in the landlord and tenant board. So that's why they sometimes steer away from that tribunal. The Residential Tenancies Act, or the RTA, which we'll refer to it as, it came into effect on January 31st, 2007. The Residential Tenancies Act creates a rental housing system that protects tenants, helps landlords, and promotes investment in Ontario's rental housing market. Or more so, it's supposed to promote investment in Ontario's rental housing market. This particular piece of legislation affects 1.4 million renters in all of Ontario. So the LTB, or the Landlord and Tenant Board. The LTB resolves disputes between landlords and tenants, and either one party can apply to the board. They have to pay the board filing fee, and a notice of hearing will get mailed to them. The Landlord and Tenant Board is similar to a court-like setting. Disputes can be worked out through one of two ways or both ways. Let's talk about mediation and adjudication. I always recommend mediation, and I'll tell you why. At mediation, you can do it on the same day as your hearing. A landlord and tenant board mediator helps the landlord and tenant reach an agreement that they are both satisfied with. Meaning, if you do agree to a solution, you do have more control or more of an influence on the outcome of your matter. Whereas if you don't agree about a solution in mediation, Whatever happens in mediation stays in mediation, meaning that you will continue with your hearing in front of the adjudicator and you can't bring up anything that you discussed in mediation. When you go in front of the adjudicator, um, keep in mind the adjudicator is the deciding member or the judge per se, and they are deciding on many files and matters throughout the day. So they don't really care about the details, the minor details to your matter. They don't have any emotional ties to the matter. All they do is they hear the matter and they apply the law, and that's it. And they send out an order in the mail. Okay, so let's start getting into what realtors can ask prospective tenants for when advertising a property for lease. Number one is, what is the income? Number two, if you work and where you work. How many people will be occupying the rental unit? Are there any pets? This is the time to ask, okay, especially when it comes to pets, because a decision can be made before a rental agreement is entered into. If they are a smoker or non-smoker, permission for a credit check, references from the previous landlord, and I also recommend references from the previous landlord, because more than likely the former landlord wants to get them out, so they will give a good reference. And last but not least, a credit report, an Equifax credit report. Okay, what realtors cannot ask for when they're advertising a property for lease on the MLS. Okay, I come across this many times. Okay, so the first one is, are they pregnant or do they have any children? And these are basically violations of human rights. They're human rights. That's why we often let landlords know to steer away from these type of questions. Number two, if you plan on having children or you plan on having more children. If you're married, divorced, single, your marital status, religion or ethnic background, sexual orientation, if they are on any public assistance, being welfare, OW, ODSP, if they have a disability, their age, if they're a Canadian citizen. Usually, and more often than not, if a realtor asks any of these questions or they won't rent to a prospective tenant because of the answers, this could be grounds for discrimination and a human rights violation. And here's the trigger. The brokerage and the sales representative can be both found liable and accountable. So I recommend to steer away from these questions. Here's what not to include on the MLS listing, comments, and broker's remarks. Let's go through this. Number one, only for basement, tenant must pay 40% of the utilities. Well, the legal sharing of utilities is either based on square footage or a split of 2/3 or 1/3 of the payment. Number two, the credit report, employment letter, and a copy of a piece of photo ID. Asking for an employment letter is illegal under the Ontario Human Rights Act, and the reason for that is because sometimes there are some people out there that are not working. However, their support will cover the rent. So really it doesn't matter if they're working or not, or it shouldn't matter if they're working or not. Getting back to number two, prospects are also not required to provide a piece of photo ID. Grass cutting and snow removal are the responsibility of the tenant. Municipal Safety, Housing, and Maintenance Standards states that it is the owner's responsibility to make sure that the property can be safely entered and exited. The Residential Tenancies Act does not address snow removal directly, and it neither does grass cutting. It is the landlord's responsibility to make sure that the property is kept in a good state of repair, is fit to live in, and complies with health and safety standards. That means if you file an application to the Landlord and Tenant Board about snow removal, the member or the adjudicator would decide whose responsibility snow removal and grass cutting is. It's usually at their discretion. However, in my experience, they will put that on the landlord. Number four, the tenant to provide post-dated checks. The landlord cannot require the tenant to pay rent by way of post-dated checks, cash, direct deposit, auto withdrawals. The tenant has to be free to pay their rent any which way they want to. Number 5, tenant to provide tenant's insurance before move-in. Okay, so there's a lot of hoopla around this tenant insurance. I'm going to be clear. Tenant's content insurance is for the benefit of the tenant and is not a requirement to tenancy. As per the Ontario Standard Lease, Section 11, it allows for the option of insurance. However, there's no way to enforce a tenant to obtain insurance, meaning that if you have a tenant that wants to move in or does move in and does not provide you with an insurance policy, there's no way to evict them because of that. Let's talk about the Form 400, the agreement to lease a residential property. The Form 400 is the brokerage's requirement to release commissions to the realtor upon completion. This is not a lease agreement. Form 400 is an offer to lease. It's similar to an agreement of purchase and sale offer agreement. The Ontario Standard Lease Agreement. Now, this is the Ontario Standard Lease Agreement is required to be attached to Form 400 for the brokerage to also release commissions. This is the actual lease agreement. Here are a couple of differences between the Form 400 and the Ontario Standard Lease. Form 400 is an offer to lease, and it's usually the first step to leasing a residential property. There may be subject conditions that need to be fulfilled, and it is usually signed first. The Ontario Standard Lease, however, is more detailed. It's longer in length than the Form 400, and it replaces Form 400 when it's signed. The Ontario Standard Lease and what happens if a copy is not provided to the tenant. So the Ontario Standard Lease came into effect in April of 2018, and the landlord must give the tenant a copy of any written lease within 21 days after the tenant signs it. That is the law. The lease should not contain any terms that are inconsistent with the Act. If the lease does contain a term that is inconsistent with the Act, that term will not be enforced by the Landlord and Tenant Board. For example, an example of inconsistent terms are no pets, damage deposits. These are terms that go against what the RTA allows. Okay, if the landlord fails to provide the standard lease within 30 days after the renter has began withholding rent, the renter does not have to repay the 1 month's rent. So this is one of the reasons that a tenant can hold back rent. Tenants cannot withhold more than 1 month's rent and must continue paying the rent for the term of the lease, even if the landlord never gives them the standard lease. What else should realtors provide to their clients in addition to a copy of the lease? Well, realtors representing landlords must also provide new tenants with information about the rights and responsibilities of landlords and tenants and about the role of the LTB. The landlord must give this information to the tenant on or before the start of the tenancy. So this is the information for new tenants brochure. Now, a few of you have given your email addresses on your business cards to Rob, in which we will send you a copy of this brochure. If you would like a copy of this brochure, you can check out our contact info on our website, stonegatelegalservices.ca. Shoot us an email, and I'd be more than happy to send you the information for new tenants brochure. Let's talk about rent deposits. The landlord can collect a rent deposit from a tenant on or before the start of a new tenancy. The deposit cannot be for more than 1 month's rent. The deposit cannot be used for anything else except for the last month's rent. If a landlord gives a notice of rent increase, the landlord can also ask the tenant to increase the rent deposit by the same amount. So what are illegal deposits? The following deposits are illegal. Okay, so damage deposits, key deposits we'll come back to, vehicle deposits, utilities deposits, pet deposits, repair deposits, and I'm seeing this more and more often, light bulb deposits. Let's go back to key deposits. In the Ontario Standard Lease, it allows for a landlord to obtain a key deposit that is refundable. However, here's the catch. The refundable key deposit must be for the cost of the key and not a $200 or $300 deposit. Okay, so rent payment methods and receipts. The landlord cannot require the tenant to pay rent by any way of post-dated checks, cash, direct deposits, auto withdrawals. We've already covered that. Here's the link to this chain. The landlord must provide a receipt for any rent payment, rent deposit, or any other charge upon request by the tenant. The landlord must also provide a former tenant a receipt if that person asks for one within 12 months after the end of the tenancy. And the landlord cannot charge a fee for providing this receipt. This is not a service, it's a receipt. So rent increases. So before I start talking about these forms, I just want you to make a note. Realtors, property managers, nobody else except for the landlord or the landlord's legal rep is allowed to put pen to paper and serve these notices. If you want to risk doing that, you will risk your application and your hearing getting dismissed. So, rent increases. The rent can be increased if at least 12 months have passed since the tenant first moved in or since the tenant's last rent increase. The landlord must provide 90 days notice in writing of any rent increase. The guideline is set every year by the Ontario government and rental increases must be as per the guideline. Any rent increases over the guideline must have the landlord and tenant board's approval. Okay, so getting back to the common questions that realtors ask before listing a property for sale. I get calls daily, if not weekly, and from one of these asking about these questions. Here we go. Beta, can we evict a tenant and sell a property? Or Beta, the tenant isn't allowing for showings. Can we kick them out? And here's another one. Beta, the landlord's lease is coming to an end. Can we give the tenant notice to move? And the answer to all these three questions is no. Tenants have what's called security of tenure. And what that is that just because that lease is coming to an end, or just because the landlord is selling the property, doesn't mean that the tenant has to move. A tenancy can only be terminated when in one of three ways. Okay, well, the first way is if the tenant decides to leave and gives notice. The second way is if the landlord and tenant agree to mutually terminate their tenancy. Or the third way, by way of court order. Let's talk a little bit about the infamous N12, notice for the landlord or purchaser's own use. So as you can see, it's highlighted. Realtors cannot serve this notice. I'm going to stress this because this is the notice that realtors are using more and more in order to try and complete their sale, but they shoot themselves and their clients in the foot because when it reaches the board, if it reaches the board, when it's disclosed to the member that the realtor issued this notice, the hearing will get dismissed, the application will get thrown out, and your closing will be delayed. Okay, so better do it the right way than have your hearing dismissed. The N12 can be used in one of two ways. For the landlord's own use, that means if the landlord's immediate family member or caregiver requires the rental unit for their own personal use. And the person that's moving into the property has to be occupying the rental unit for residential purposes for at least 1 year. Now, this is the way the realtors are using it, is that when they obtain a firm agreement of purchase and sale, they're saying to the tenant that the purchaser requires the property for the purchaser's own use. The landlord, this notice can be served by the landlord or their legal rep if the landlord has signed an agreement of purchase and sale, the property contains 3 units or less, and the purchaser or purchaser's immediate family member or caregiver will be moving into the rental unit for at least 1 year. This notice cannot be issued if the landlord is a corporation or for the landlord's extended family, their brother, sister, aunt, or uncle. Again, realtors cannot serve this notice. The N12 must be served on good faith. So let's define good faith. Good faith is having the genuine intention to occupy the rental unit for residential purposes. Landlords should not serve the N12 to a tenant because they are experiencing problems with the tenant or they want to raise the rent, and they believe it's the easiest way to get rid of the tenant. This is the reason not to serve the N12. A tenant can file a T5 bad faith application against a former landlord for bad faith within 12 months of the date that they moved out. That's the limitation period and is a very long one. If a landlord is found to have served a notice on bad faith, the Landlord and Tenant Board can order the former landlord to pay the difference between the new rent and the previous rent, moving costs, storage fees, application fees, and the list can go on. Again, realtors cannot serve this notice. So with this notice comes compensation. If the landlord serves the N12 because the landlord, a member of his or her immediate family, or a person who is going to be providing care services will be moving into the property, then compensation equivalent to 1 month's rent, let me be clear, equivalent to 1 month's rent, or offering the tenant a unit that is acceptable to them. Just a side note, that the unit offered to the tenant must be owned by the same landlord. Compensation must be paid before the termination date. So here's the way I remember it, okay? There is no termination without compensation. There should be a declaration or affidavit submitted to the Landlord and Tenant Board as well. Again, realtors cannot serve this notice. Here's some important information that's right on the notice. If the tenant wishes to dispute this notice, they are not obligated to move out of the rental unit and can remain in the unit until the hearing date. It says it right there. What if you disagree with the notice? You do not have to move out if you disagree. If the tenant decides to leave earlier than the termination date indicated on the N12, then the landlord must provide a refund of any extra rent in his or her possession, as well as to provide 1 month's compensation. Again, realtors cannot serve this notice. How do we cancel the N12? Okay, so let's say somebody changes their mind, or the landlord, they woke up and they said, I issued this on bad faith. How can I take it back? Well, there's really no set way to cancel an N12 once it is served onto the tenant. Landlords must make certain that the person whom they have set out to move into the rental unit is 100% committed before serving the N12 to the tenant. Someone changing their mind is not a reason to to cancel an N12. If, for example, somebody changed their mind, the person changed their mind, you may want to notify the tenant right away along with a letter explaining the change in the circumstance. You should also inform them that they can disregard the N12 and continue their tenancy. And what if it's too late to cancel? If the tenant has already signed another lease and is moving out, compensation still must be paid. And if the tenant files an application for bad faith, they can sue the landlord for up to $35,000. How you can serve the tenants. So I know that email is very convenient and a quick way of service. However, the Landlord and Tenant Board has their own rules around how a notice can be served. Landlords must serve their tenants according to the rules of the LTB, and they must fill out a certificate of service and file with the notice for a hearing. The landlord may serve their tenants in one of the following ways: handing it to the tenant, handing it to another adult in the rental unit, placing it in the tenant's mailbox where mail is usually delivered, sliding the document under the door or through a mail slot, faxing it to the tenant's residence or place of business, courier, registered mail, or express post. Just a side note: if you are serving a notice via mail or registered mail or express post, you must add 5 days to the termination date. Again, realtors cannot serve notices. So what are other reasons for evictions? Okay, so the landlord can give notice to a tenant or the tenant, if the tenant's guest, or someone who lives in the rental unit is not paying the full rent, persistently late in paying the rent, causing damage to the property, committing illegal activities, affecting the safety of others, disturbing the enjoyment of the other tenant or landlord, allowing too many people to live in the rental unit, not reporting income in subsidized housing, or the other two reasons, landlord or purchaser's own use, or major renovations are required, which will require building permits and demolition. This brings us to the conclusion of our presentation. Again, I'd like to thank you for coming on and going through the slides with me. If you have any questions, please reach out to us. You can follow us on social media or check us out on our website at Stonegate Legal Services. .ca. The great part of this presentation is you can forward the link to your clients if they ever have any questions regarding leases. Again, thank you very much, and I hope you have a good day.